The United States Department of Justice is currently navigating an institutional hemorrhage of unprecedented proportions, a slow-motion collapse that is playing out in federal courtrooms across the country. A staggering wave of resignations, forced departures, and firings has fundamentally gutted the ranks of career federal prosecutors. The seasoned attorneys who once formed the backbone of the nation's legal apparatus, the line prosecutors and assistant United States attorneys who handle the grueling day-to-day mechanics of the federal justice system, are vanishing. In their wake, they have left behind a skeletal crew of overwhelmed, undertrained replacements who are now finding themselves trapped in a bureaucratic nightmare. The chaos has reached such a critical mass that the lawyers left standing are not just failing to keep up with their dockets. They are being subjected to humiliating, career-altering sanctions by federal judges who have completely run out of patience. We are witnessing a historic breakdown where the inability to process basic paperwork is resulting in severe civil contempt orders, exposing a deeply broken system that is crushing the professionals forced to operate it and inflicting profound trauma on the vulnerable populations caught in its gears. To fully grasp the magnitude of this crisis, one must understand how the Department of Justice is attempting to plug the massive holes in its sinking ship. With thousands of career professionals abandoning their posts, the administration has resorted to drafting military lawyers from the Department of Defense. These Judge Advocate General, or JAG, officers are being suddenly uprooted from their military careers and thrust into the role of Special Assistant United States Attorneys. Historically, becoming an Assistant United States Attorney was one of the most fiercely competitive and highly coveted achievements in the American legal profession. It required graduation from top-tier law schools, prestigious clerkships, and years of specialized field experience. An attorney did not simply walk into federal court representing the United States government without undergoing a rigorous professional residency, meticulously learning the complex nuances of federal civil and criminal procedure under the watchful eyes of veteran supervisors. Today, that standard has been entirely obliterated. JAG lawyers whose expertise lies in the Uniform Code of Military Justice and the specific procedures of military tribunals are being thrown into the deep end of the federal judicial system with virtually no orientation, no institutional support, and no specialized training in the labyrinthine rules of federal immigration and civil rights law. They are stepping into hollowed-out offices where institutional memory has been erased, frantically trying to navigate an entirely different legal universe. It is akin to taking a highly skilled military trauma surgeon and abruptly demanding they perform complex neurosurgery in a civilian hospital without a support staff. This structural desperation recently culminated in a stunning courtroom showdown in Minnesota, exposing the human cost of this administrative catastrophe. At the center of this debacle is a military JAG attorney named Matthew Isahara, who was detailed to the local U.S. Attorney's Office to help manage a tidal wave of litigation. Since his arrival, Isahara was reportedly assigned an impossible caseload of nearly 130 habeas corpus petitions in a single month. A writ of habeas corpus is one of the oldest and most sacred protections in the legal system, a fundamental constitutional guarantee that allows individuals to challenge the legality of their detention and demand that the government justify their imprisonment before a judge. Processing just one of these petitions requires meticulous attention to detail, rigorous fact-checking, and strict adherence to unforgiving judicial deadlines. Dumping 130 of these complex, high-stakes constitutional cases onto the desk of a single attorney who has never practiced in federal court is a recipe for inevitable disaster. The inevitable disaster arrived in the case of Rigoberto Soto Jimenez, a Mexican national who had been living with his lawful permanent resident spouse in Minnesota. Swept up in a massive, aggressive immigration enforcement dragnet, this individual was pulled from his life and abruptly shipped by U.S. Immigration and Customs Enforcement, IC, to a detention facility in El Paso, Texas. When his defense attorneys successfully filed a habeas corpus petition, U.S. District Judge Laura Provenzino reviewed the facts, determined that the detention was unlawful because the government lacked the proper administrative warrants, and ordered the man's immediate and unconditional release. Crucially, the judge's order was highly specific. She mandated that the federal government release the man back in Minnesota, the state where he was originally apprehended and where his family resided, and explicitly ordered that all of his personal property and identification documents be returned to him upon his release. What followed was a masterclass in governmental cruelty and bureaucratic negligence. IC completely ignored the judge's explicit geographic parameters and released the man in El Paso, Texas, a city and state entirely unknown to him. To compound the indignity, they threw him out into the streets without his driver's license, his consular identification card, his money, or his wallet. He was left stranded thousands of miles from home, stripped of his identity, with no means to navigate a high-security border town or secure a flight back to his family. His desperate defense attorneys were forced to scramble in the middle of the night to find emergency shelter for him and independently arrange his transportation back to the Midwest. When this flagrant violation of a federal court order was brought to the attention of Judge Provenzino, the simmering frustration of the federal judiciary finally boiled over. For months, judges across the district had been issuing warnings, tiptoeing up to the line of severe sanctions as they watched ICE operate with a terrifying level of impunity. Federal judges had explicitly noted that the immigration agency was violating more court orders in a single month than most government agencies violate in their entire existence. The government's defense, delivered by overwhelmed attorneys like Isahara, was consistently the same: an apologetic refrain of severe understaffing, crushing caseloads, and logistical delays in communicating with a rogue law enforcement agency. But a federal judge's patience has limits, especially when constitutional rights and human dignity are being trampled. Judge Provenzino correctly noted that the court would never allow a private attorney or a regular citizen to rely on the excuse of being too busy to justify the blatant disobedience of a judicial mandate. The government, she declared, is no different. Rejecting the notion that a self-inflicted staffing crisis absolves the Department of Justice of its legal obligations, she took the extraordinary and humiliating step of holding Matthew Isahara in civil contempt of court. She ordered that the government attorney be held personally responsible for a coercive fine of $500 for every single day that the migrant's identification papers were not returned. The imposition of a civil contempt order against an assistant U.S. attorney is a legal earthquake. In the highly hierarchical, reputation-driven world of federal law, a contempt finding is a devastating stain. It is a permanent mark on a lawyer's record that can effectively derail future career prospects, block partnerships at prestigious private law firms, and follow the individual through every background check for the rest of their professional life. If an attorney is ever threatened with contempt, the standard operating procedure is to move heaven and earth, upend the entire agency, and stop all other operations until the court's demands are met. But in the current hollowed-out state of the DOJ, the internal alarm bells that should have triggered an immediate, full-scale response simply did not ring. The warning signs were ignored until the judicial hammer actually fell. In court, Isahara issued a profound apology. By all accounts, he does not appear to be a lawyer acting with malicious intent or deliberate cruelty. He is a soldier who followed orders to step into a breach only to find himself drowning in a bureaucratic quicksand. He openly admitted to the judge that he had dropped the ball and that the case had simply slipped through the cracks of his 130-file mountain of paperwork. He confessed that he had failed to promptly transmit the release order to ICE officials in Texas and had failed to respond to the frantic pleas for help from the migrants' defense counsel. It was a humiliating public admission of total systemic failure. Yet, this situation reveals a much darker reality about the relationship between the Department of Justice and the agencies it represents. When an attorney calls their client, in this case U.S. Immigration and Customs Enforcement, and informs them of a binding federal court order, the client is legally obligated to comply immediately. However, ICE has increasingly operated as a rogue entity, seemingly emboldened by a tacit green light from the highest levels of executive leadership to act outside the boundaries of the law. They drag their feet, engage in bad faith miscommunications, and treat federal judges as mere suggestions rather than ultimate authorities. The most damning piece of evidence exposing this bad faith is how quickly the situation was resolved once the financial penalty was imposed. Almost miraculously, on the very day the $500 daily fine was enacted against the DOJ lawyer, the lost identification documents suddenly materialized and were returned. The government proved in that instant that it possessed the logistical capability to comply with the court's order all along. It simply lacked the institutional respect or the political will to do so until a judge threatened to seize the personal funds of its legal representative. If the papers could be located on Thursday under the threat of monetary sanction, they could have been located on Wednesday to spare a human being the terror of being stranded, undocumented in a border city. The collateral damage of this administrative chaos is twofold, destroying both careers and lives. On one side, you have professionals whose reputations are being sacrificed on the altar of a manufactured manufactured staffing crisis. Another government lawyer detailed to the same overwhelmed Minnesota office reportedly suffered a visible breakdown in open court shortly before Isahara's sanction. Overwhelmed by the futility of trying to force a recalcitrant agency to obey the law, she told the presiding judge that the job was intolerable, practically begging the court to hold her in contempt just so she could be sent to a jail cell and get 24 hours of uninterrupted sleep. She was subsequently removed from her detail. These are the visceral psychological breaking points of civil servants who are being ground into dust by a broken machine. On the other side of this crisis, and far more importantly, are the human lives being toyed with. While legal analysts dissect the career implications for a JAG officer with a contempt citation, we must recognize that a missed deadline in a habeas corpus case is not just a scheduling error. It is the physical and psychological torment of a human being. A piece of paper falling through the cracks means a person is subjected to prolonged unlawful incarceration. It means families are kept separated. It means individuals are subjected to the horrific conditions of detention centers, flown across the country like cargo, and discarded onto foreign streets without the basic tools needed to survive. The ultimate fault for this cascading catastrophe does not lie with the harried, inexperienced lawyers trying to bail out the ocean with a teacup. The blame rests squarely on the shoulders of the high-level architects of this policy, the ideologues and political appointees who initiated these massive deportation sweeps without building the judicial or administrative infrastructure required to process them legally. By simultaneously flooding the system with arrests and gutting the ranks of the lawyers needed to process those arrests, the leadership has engineered a state of perpetual constitutional crisis. They have created an environment where the denial of due process is no longer an accidental byproduct, but rather the inevitable built-in feature of the system itself. As federal judges continue to escalate their responses from stern warnings to actual financial sanctions, the credibility of the United States Department of Justice hangs in the balance. The justice system relies entirely on the premise that the government will bind itself to the rule of law. When the government demonstrates that it will only obey a court order when an individual attorney is threatened with personal financial ruin, the moral authority of the state evaporates. The floodgates of judicial retaliation have now been forced open. If this pattern of lawlessness, understaffing, and rogue agency behavior persists, the courts will have no choice but to continually deploy their ultimate coercive powers. The tragedy is that the true perpetrators of this chaos remain shielded behind the bureaucracy while the junior lawyers taking the fall and the vulnerable migrants suffering the consequences are left to pay the ultimate price.